This Honorable Court of Appeals of Tennessee is now in.
Thank you, Mr. Hivner, and on behalf of Judge Bennett and Judge McBrayer, we welcome counsel to this oral argument, which we are live streaming to maintain our open court practice. We will conduct the hearing in the same manner as if we were all together in the courtroom. Each of you has 15 minutes to argue, and Mr. Bass has reserved some of his time. Unless there are announcements, we'll ask Mr. Hivner to call the case.
Timothy O'Guin versus State of Tennessee.
Good morning, judges, and may it please the court. Summary judgment is an effective time-saving and cost-saving method to avoid trial where there are issues that don't need to be tried, where the evidence could not ever favor the non-moving party. The summary judgment process presupposes two things. First, that the movement will identify for the court the specific issues that they contend there is no contrary evidence, nothing that could support the non-moving party. And the second is that the trial court will consider all of the evidence submitted in the light most favorable to the non-moving party, taking all inferences in favor of the non-moving party, basically giving the benefit of the doubt to the non-moving party on the issues at hand. Unfortunately, that did not happen here. The state in the trial court moved on a single issue. In its motion, in its memorandum, and in its statements of undisputed material fact, the state moved on whether plaintiff could offer sufficient evidence of causation to satisfy his burden of proof and burden of persuasion in a premises liability case. To be sure, there are many other elements that go into any negligence case. We must ultimately prove at trial that the state owned or operated the facility, but the state did not move on that. We must ultimately prove on trial each of Mr. O'Guin's sustained damages, including his medical bills. The state did not move on that. So the claimant addressed appropriately the specific issue brought before the trial court and offered evidence of what caused Mr. O'Guin to suffer a fatal fall injury outside of the defendant's nursing home facility or veterans home facility. The state did not respond to that evidence. The trial court did not view it in the light most favorable to the non-moving party. We know that in part because the trial court did not consider it. The trial court did not address it. Neither the state nor the trial court acknowledged its existence. Fortunately, we're here on a de novo standard, so this court is able to review that evidence with fresh eyes. Thinking about the summary judgment standard, I was rereading Rye this morning, and it's a lengthy opinion, and I noticed in the majority, Justice Clark quoted from then Chief Justice Rehnquist in the Celotex opinion. And he said, "Of course, a party seeking summary judgment always bears the initial responsibility of informing the court of the basis for the motion. The basis that the party seeking summary judgment in this case sought was specifically causation. And on causation, the claimant offered three types of evidence that frankly rarely is available in any premises liability case. The claimant submitted the state's own, the defendant's investigative reports, and the state's own, the defendant's testimony. The investigative reports in this case are not some handwritten note that was filled out by a convenience store clerk, but they are federally mandated. They are required by law investigations to be performed the same day an incident occurs, any sentinel event like this, as well as after time for deliberation. And in those reports, which we've submitted, the state found, based upon their investigation, based upon interviewing an unnamed eyewitness, based upon their observations at the scene, based upon all that they could observe, under federal law, their required report was that Mr. O'Guin was rounding a corner on the front sidewalk and was unable to negotiate the turn.
So that sounds like to me, your client was at fault then.
That is an inference that could be taken.
Okay, so what's the other inference? The report is that your late client couldn't negotiate the turn. What's the other inference here?
In this case, we also have three prior incidents that help inform us of the problems with the sidewalk and curbs outside of the state's facility. Now, what we have are 3 reports, not documented, but personally observed by the facility administrator. And in each of those incidents, the facility administrator, according to his testimony, he observed another resident, another wheelchair-bound resident, who was unable to effectively navigate the 90-degree angles, the right angles, at various points around the facility and had fallen off. And in his testimony, he also acknowledged
Various points around the facility. Do we know how those points in the facility compare to the point where your client had his fall?
we do know that they are not, we have the, I believe it's from Google Maps, but the overhead satellite view of the facility where we can compare and contrast and verify that each of those points is another 90-degree turn where the sidewalk makes a 90-degree turn back towards the facility.
So,
And-
I mean, and I want to say I appreciate including the photographs in your brief. That's very helpful in a case like this. But I want to ask, based on my observation of the photograph you included, this looks like a standard sidewalk and curb. Am I correct about that? Is it nothing different from a typical curb right out in front of the courthouse here?
I think there are 2 things that make this curb and sidewalk unique. The first is that there is a slope that is observable in the photographs as well. There is a slope coming from what I would describe as sort of the meat of the building where the windows are, sloping down towards the horseshoe-shaped ingress, where that 90-degree turn meets. So you have a slope direction. And the second thing is you have guests who are wheelchair-bound residents. Now, not everybody there is in a wheelchair, but these are people recovering from various conditions. And so they have a foreseeable population of individuals who have been proven in the past, but from prior similar incidents, not to be able to reliably navigate those turns. I think in my household, when there's an insect found in the house, I'm the one that gets called. Daddy gets called from anywhere in the house. It doesn't matter if I'm outside or wherever. And when I come in a room,
Or what you're doing typically, does it?
Exactly. When I come in the room and turn on a light, if I see 3 cockroaches scurrying for the walls, I can safely assume there's a concern. There's a foreseeable risk that there's more cockroaches behind the walls than the ones that I've seen. In this case, the facility administrator didn't document those prior incidents. They didn't produce any report of any prior incidents. We only know about those 3 because he recalls personally observing each of those 3. Well, 3 times seeing people fall in a wheelchair where they don't have a lot of ambulation, they're not able to effectively catch themselves if they're falling. 3 times seeing a person in a wheelchair fall off a curb down onto asphalt should be enough for a rational person to be concerned about the risk of it occurring in the future. To be sure, Mr. O'Gwen suffered the worst outcome possible. But as this court said, just because an accident is freakish does not per se make it unforeseeable. Mr. O'Gwen's injuries were the worst one could ever fear. But the fact that
Mr. Bass, does it matter that he was told to not go out beyond a certain area? And if he did, he would need an assistant to push the wheelchair?
Judge, that could matter if 2 things were different. The first is if they had moved for summary judgment on comparative fault. If they had, they would have the burden of proving that because that is their burden of proof at trial. It is not a matter like where we have the burden of proof. They can simply bat it over under the put up or shut up standard. The second is if there was not contrary evidence from that. Now, the state from the beginning has taken that record and tried to run with it and said that he was told not to go there. We deposed Nurse Bell, and you can see it in footnote 4 at page 16 to 17. I quoted liberally from her testimony. She said she didn't tell him he could not go out there. He was fine to go out in that area. He was not doing anything wrong. He was not supposed to do laps around the building or a full lap around the building, but where he was completely permissible. On a summary judgment standard in particular, no, Judge, it would require a lot of inferences in favor of the state to conclude that Mr. O'Gwen had been at fault for his own injuries by doing that, and certainly to conclude that he was at fault more than 50% as a matter of law, or 50% or more as a matter of law, by going in an area that the unrebutted testimony of the person who documented that is he was allowed to go there.
Let me ask you a question about your notice argument here. As I understood it, you also moved for summary judgment on liability. Isn't that correct?
I moved for summary judgment on behalf of Mr. O'Gwen on all elements in order to, we were told we had to wait for summary judgment before we could try. So we moved for summary judgment on all elements in order to narrow the issues for trial, because on a number of them, there is no contrary evidence.
All right. Thank you, Mr. Bass. We'll hear from you on rebuttal. General Bergmeyer.
Yes, Your Honor. May it please the court, Stephanie Bergmeyer here for the state of Tennessee, who is the defendant in this case through the Tennessee State Veterans Home. We respectfully request that the summary judgment be affirmed on the basis that the plaintiff has failed to provide sufficient evidence to establish causation in his claim. The evidence put forth by the claimant to establish causation is undisputed. There's a federal report, as mentioned, and deposition testimony. The first page of that federal report states that Mr. O'Gwen rolled his wheelchair off the side of the curb. On the second page of that report, it states that Mr. O'Gwen was unable to negotiate the turn. His wheelchair hit the edge of the curb and he fell from the wheelchair onto the pavement. The deposition states something similar, that at least one of the wheels touched the edge of the curb or went over the edge of the sidewalk. We submit that this evidence is insufficient to establish causation. In other words, this evidence merely states that Mr. O'Gwen's wheelchair left the sidewalk. This is not sufficient evidence.
Was the sidewalk wide enough to accommodate Mr. O'Gwen's wheelchair?
Claimant has not submitted any evidence that it was not wide enough.
Okay.
This court has stated time and again that it will not presume negligence from the occurrence of an incident. And in its brief, the state identified a string site of cases where this court has stated that if plaintiff is unable to identify what caused a fall, summary judgment is appropriate. This case is similar to the Puller case in which this court affirmed summary judgment for a defendant. In the Puller case, the plaintiff died after falling off defendant's roof. The evidence was that there was a defect in the ladder, and a paramedic estimated that the decedent had fallen from a ladder 15 feet to the ground. This court looked at the evidence and said that there was no evidence of what caused the decedent to fall from the ladder, or whether the defendant's conduct was substantially connected to the injury. Here, the evidence is similar, that Mr. O'Gwen's wheelchair rolled off the curb. It's just the same as the Puller plaintiff falling from the ladder, and this evidence is not enough. The burden is on the plaintiff to establish that defendant's conduct was the probable cause of the injury. And here we are left with mere speculation as to what caused Mr. O'Gwen's wheelchair to come off the curb and leave the sidewalk. Therefore, we think that the commission's summary judgment should be affirmed. Now, because summary judgment was properly granted to the state, this court need not consider the remaining issue raised by plaintiff in his brief, issues 2 and 3. None of the evidence considered by the commission in its order on summary judgment establishes probable cause of why Mr. O'Gwen's wheelchair left the sidewalk. It was not an error for the commission to consider the evidence put forth of whether a dangerous condition existed when deciding this causation question. This is all part of the question on whether defendant's conduct was the probable cause of the injury and part of the causation analysis. Any determination of the other negligence issues, which was raised by plaintiff in his motion for summary judgment on notice or on this dangerous condition, does not result in any error, because the commission's order not only granted the defendant summary judgment, but it denied summary judgment to claimant. So it was proper for the defendant to go through that analysis and address those issues. In addition, if the commission considered any additional evidence, such as the prior incidents that claimant has mentioned in this case, that could only help claimant establish causation. It could not hurt the analysis. So that's following the summary judgment standard to look at all evidence and view it in the plaintiff's favor. Something to note of the prior incidents, these were not submitted in response to defendant's summary judgment. They were put forth to the commission on the claimant's own motion for summary judgment. So these were not facts that the claimant raised as material evidence or relevant to the defendant's causation analysis. It was put forth in defendant's own motion for summary judgment. In addition, these additional incidents, even if you consider them in the causation analysis, they're distinguishable and insufficient to establish what the cause of this plaintiff's fall was.
And why are they distinguishable?
They were in other areas of the facility. None of the prior events were in the same area of the sidewalk. Two of the incidents involved motorized wheelchairs, where in this case, the claimant was in a self-propelling wheelchair. And according to the deposition testimony of the administrator, one prior event occurred because the resident was not looking where he was going, and another resident had the sun in his face. And the third incident occurred on a service dock, so it was a different area of a sidewalk. It wasn't the same as the turn in the sidewalk curve. So these prior events, even if you consider them, they are insufficient to establish causation in this case.
Was there a curb cut at the sidewalk where Mr. Gwynn went over the edge?
There is the photographs in the evidence, but I don't believe there's been any specific evidence put forth in the record on whether there was a curb cut there.
Okay.
In addition, during oral argument today, claimant mentioned what makes this sidewalk different is the slope of the sidewalk. And this is not in the record. And his mention of the slope of the sidewalk, I believe, is the first time that I've heard that argument put before the court. So I don't believe that that fact is in the record. Even if the slope of the sidewalk were a consideration, that still would not establish causation, and that any slope present is what actually caused Mr. Uglin's wheelchair to leave the sidewalk. Because we believe that the commission's order was correct and that there is not sufficient evidence of causation, the state respectfully requests that this court affirm the judgment to defendant. Unless this court has any other questions, I'll rest my argument.
Are there any other questions? Hearing none. Mr. Bass, your rebuttal.
Thank you, Judge. Before the state's argument, Judge McBrayer, you were asking about the sort of unusual circumstance of the parties filing competing summary judgment motions in this case. And I think actually from the state's counter argument, we're on the same page. The parties don't really dispute that although the commissioner, the trial judge, commented on other aspects of the case, I do not believe that they are effectively before this court. And I don't think
it strikes me, Mr. Bass, and maybe I'm misreading that both sides have a pretty good handle on what the facts are here.
Yes.
What conclusion should we reach from those facts? And you're suggesting, look, the conclusion here was wrong because, okay, yeah.
That and a summary judgment is no substitution for a trial on the merits. Of course, when you're offering up evidence on summary judgment, you're looking for evidence that is unrebuttable or unrebutted. These sort of simplistic facts, that's not the same as what this court once described as the crucible of cross-examination, where the finder of fact can review the credibility of witnesses. This is the first time the state has acknowledged its administrator's testimony or its report. What they are still asking is for this court, sitting de novo, to take inferences in favor of the state. They are still asking the court to review the evidence and say, well, it's possible that Mr. O'Gwyn was at fault. As they said in their brief, it is possible that maybe he was unable to use his wheelchair effectively. That's comparative fault allegation.
Well, isn't the state's theory that you haven't proved what caused the accident?
That is
and what is your proof of what caused the accident?
I wish that I could offer Mr. O'Gwyn's testimony, but unfortunately our best witness was killed here.
Well, we're sadly aware of that, and we wish Mr. O'Gwyn was here, but he's not. And without him, what evidence do you have of what caused it?
What we have is the circumstantial evidence by way of photographs to show the nature of the facility. We have the prior incidents to show the effect of these 90-degree curbs around 90-degree sidewalks. And to answer Judge McBrayer's question to the state, you can tell from the photographs, no, there are no curb cuts at that location.
Well, what does the photograph show was the cause?
The photographs show that there is a sloped curve, and it is in the record. It is the photographs themselves. The photographs show that the sidewalk, slopes down towards the ingress, towards the portico. The photographs show that the sidewalk is positioned a curb height up above asphalt. The past evidence or evidence of past incidents shows that residents in this facility have a frequent problem navigating that.
How do we know that's the cause? It sounds like we're speculating here. We don't know why he went off that edge, do we?
What we do know, contrary to Puller is a great example of the exception that proves the rule. In Puller, there was no testimony about how this unfortunate handyman came to become from the roof down to the sidewalk or down to the concrete down below. There's no evidence as to whether he was using the ladder even. There's no evidence that he slipped. There's no evidence that he was trying to climb down. There's no evidence to explain how it got there. In this case, the one fact that I wish Mr. O'Gwin was here to say, but we are unfortunately left without it, is what did Mr. O'Gwin see at the moment when he was going around the curve? The state wants to argue that maybe he had the sun in his eyes. It's one of the things they raised in their brief. They've offered no evidence of that. And if they did, that is the kind of thing that you try and you decide based upon the credibility of the witnesses. The state's argued that maybe he was unable to use his wheelchair effectively. There's no evidence of that. That's also a comparative fault allegation. The state has offered up speculation to try and rebut the circumstantial evidence. We are left with circumstantial evidence, and we are left, though, also.
We have no eyewitness testimony, do we?
We do not, Judge. There was one eyewitness that was not identified initially and ultimately was not able to be deposed. It's unclear what that person said, except that whatever that eyewitness told the state in their investigation is what led them to conclude the root cause was Mr. O'Gwin was unable to navigate, or I think they were unable to negotiate the curb.
So that's a given fact. Mr. O'Gwin could not negotiate a 90-degree curve.
And the question is that adequate?
Okay.
All right, thank you. Hearing no further questions, we appreciate the council's arguments, and we'll take this matter under advisement. Mr. Hibner.
Honorable Court is now in recess until 1 p.m.
Thank you, and council, you